speaker for the day, Mr. Advocate Veerabathran Prasanth, to please come and join us on the dais. I request all members to please stand for the ICA motto song.
सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामुषो पुरुषो निर्मिमाणः तदेव शुक्रं तदेव शुक्रब्रह्मा तस्मिन् लोकः शितः सर्वे तदुनाद्यभिकश्चन एतद्वैत 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 एतद्वैत.
Thank you. I'd like to warmly welcome all delegates here present for today's session on the Benami Transactions Act. As you all will be aware, the Benami Transaction Act was like a sleeping giant. The act was ready, it was drafted and kept on hold for many decades, and finally, a few years ago, it was brought into effect. And it has brought about sweeping reforms as far as direct taxation and Benami transactions are concerned. While earlier there was a view that if there's any similar issue to Benami which was found out, payment of tax or completing the assessment proceedings was equivalent to regulating and bringing normalcy to the transaction.
A very good evening to one and all present here. Apparently, after the brief introduction, and usually the practice is that the gift is given at the end, probably. But I think Abhishek has made it a point that he wants me to be feeling obligated to do well, so that I don't miss out on anything. So, to start with, like how Abhishek said, I had been working. I did law from Shastra University. It was a 5-year course, and then after that, I got employed with the City Union Bank for 2 years, and then I was working the same as Mr. K. Srinivas in the Senior Counsel, where we did a lot of civil matters and also writs. So my travel with, or my journey with law is for the last probably 10 years. Over these 10 years, 8 years I had been doing things, and in these 8 years, I had probably, speaking of how much I knew about Benami law, it was very, very small. Like probably if somebody says Benami, what I would get reminded of is what I would have been told when I was 10 years old or 12 years old, where people identify this guy as X is Benami or Y is Benami. So that was my knowledge for the last 8 or 9 years. Still, I joined chambers of Mr. R. Shivaraman, who does a lot of direct tax matters. And apparently, since Benami unit has become a part of the income tax, we are also dealing with this on a large scale these days. So as you all know, like the Benami law is in force, and it's not new that I'm very sure that the chartered accountants here will know way better than what I know. Though the legal system has been incorporated very recently, and the arrangement as such is new, but I definitely know that you will have a better idea than what I can say of what a Benami Act is. So to start with, it's the cliched definition of what Benami is. Benami is actually, the word as such derives from a Persian word or a Urdu word which means the state of being without a name. So a Benami transaction is actually when a purchase is made, a purchase of property is made or is conducted in a way that the identity of the real owner is not known. A Benami transaction is any transaction in which property is transferred to one person for consideration paid by the other person. This is the actual dictionary meaning of the word Benami. So the whole point is that A buys the property with the money of B and B's identity will not be known at any cost. So this is a Benami transaction. So there are a lot of impediments, of course. So when such a transaction happens, as you all know, there will be a lot of problems. The first thing is that the main intention of a Benami transaction would be to defraud creditors. Of course, all of you will be aware of the insolvency proceedings of those days as to how it was happening then. So the main intention of a Benami transaction those days was to start with was to defraud the creditors, and then of course to avoid payment of taxes and provisions of any other law where you can get away from paying taxes as such. So the main intent of the act which was brought into force was first to prohibit all these activities, and not just that, not just stopping all these activities, it also got extended to recover such properties which are held as Benami and to curtail. So ultimately it leads on to one thing called to curtail the black money transactions and money laundering activities and such, and consequently to check on corruption and unaccounted wealth. So the purpose of the act is to put a full stop to all these. So what happened is that the idea of Benami Act is not new. Though what we see is the 1988 Act as such. The first key step to bring a prohibition on the Benami transaction happened in the year 1973 when a recommendation was made by the Law Commission on its 57th report saying that there are too many transactions whereby the identity of the property, the owner is one, where the beneficial owner is one, where the property stands in the name of somebody else and he is deriving benefit out of it. So in 1973, the report was submitted by the Law Commission, and subsequently there was a development among the legislative body to bring in an act. However, nothing materialized for the next 15 years. So in the year 1988, amongst all the other legislations, in 1988, the Prohibition of Benami Transaction Act was introduced into the Parliament. It was also passed. Apparently, a biggest flaw in that, or probably a lacuna was there, is that it had only 9 sections, and this 9 sections was so primitive. It did not define anything at large. It did not define as to how a Benami transaction would work and how to stop such Benami transactions, where to stop, and it did not put in an adjudicating body also to govern these principles. So from 1988, though the law was in force, the Benami proceedings as such were not happening much. The transactions were always going on, and of course you might have seen in some appeals or something where there must be a reference to Benami, and like how Abhishek said earlier, it would have incidence only on your tax, but there was no way to put a full stop to how these transactions could happen. So subsequently, the erstwhile government in the year 2011 thought of bringing another legislation. So a bill was introduced, however it did not materialize. So after that, the current government, when they took charge in the year 2014 and in the year 2016, an amendment act was brought into force. Apparently, it was only an amendment act and not like how a new act was implemented in the place of the old act. And subsequently, the rules which were not there in the earlier legislation, which was not there in the earlier legislation, the new rules were also notified on the 1st November 2016. From then, the act started being in force. So, the first question I would like to ask, or probably a point of thought, is as to why there was an amendment rather than bringing in a new section. Like for instance, if everybody could see, the Companies Act 1956 was not amended, but rather it was replaced by a new act like a Companies Act of 2013. So any idea as to how or why, what is the reason for the legislation to bring in only amendments to that effect? Yes, correct. Exactly. So the main intention of this statute or the legislature is not to let anybody go out of hands. If at all a new act is implemented, so there is a lacuna, or there is a period of 28 years between the old act and the new act, and there were several transactions which were found to be Benami but were left unattended to because there were no rules or legislation as such. So the government was so keen in addressing this issue, and they definitely wanted to bring everybody under the curfew or everybody under the bar. So that is the reason why an amendment was proposed rather than repealing the old act and replacing it with the new act. So, so there are vital differences as to what the old act carried and what is there in the new act. So in the old act, the act was called as Prohibition of Benami Property Transaction Act, and the new act is called as Benami Transactions Prohibition Amendment Act of 2016. The old act, when it had only 9 sections, the new act had 72 sections. The old act did not have any rules per se, whereas rules were prescribed separately as to how to deal with the property. And then implementation, acquisition, penalty procedures were not clear and strong. There was no sections or procedures in law to penalize a person or bring in a prosecution as such. But the new law came in with a lot of amendments, a lot of new ideas to penalize such people, to prosecute such people who are involved in the Benami transaction. And then there was no exemptions in the definition of Benami transaction, and more importantly, there were no authorities as such. Whereas this act has categorically put in several people. It has established something called the Benami Prohibition Unit, where several people, it is a part of the income tax department, as you all know, and they specifically work on the Benami matters. One more important thing is the effective day of implementation. So, when the first law was brought into force, Section 1.3, which brought in or which gave the power or which brought in which implemented the act per se, said as thus: the provisions of Section 3, 5 and 8 shall come into force at once, and the remaining shall be deemed to have come into force on 19th of May 1988. See, this is for one thing that it is a penal statute, and sections 3, 5 and 8 are the charging sections. While section 3 says such activities of Benami are prohibited, 5 says the property will be confiscated, and 8 says defines as to how adjudicating authority or the body works. Since these sections are punitive in nature, the statute made it a point that 19th May, that is when it gets consent of the president to be brought in force, whereas 3, 5 and 8, the other sections were brought in force much earlier. The new act, however, retained the words 19th of May 1988. For the point, like what I said earlier, it did not want anybody to get out of the fold of Benami. Even people who have committed Benami transaction earlier and have been booked on various grounds are to be brought under the curfew of the new act. So it retained the word 19th May 1988. So if at all there is a question as to whether if there was a Benami transaction somewhere in 1990s, and will we be coming under the provision, will a client of yours will be penalized under the provision, or will he be subjected to the provisions of this act? The answer is yes. So if somebody gets a notice, you cannot take a plea that the act is new, because it has effect right from the year 1988. So the new act, like I said, has 72 sections in total. So the first chapter as such deals with the preliminary portions, where it defines as to where the act is along which provision or which extent the law is implementable. And second one is as to what a prohibition of Benami transaction is. The third one deals with the authorities and the powers of authorities as such. And the fourth one is the procedure as to how the attachment goes, and then how the adjudication of the Benami proceedings will go. And finally, confiscation of property, that is where the property will become the property of the government. And then the appeal remedies, then special courts to prosecute such people who are involved in the Benami transactions. Subsequently, offences and prosecutions, and then miscellaneous provisions where a few sections and few acts were repealed by the act. The first portion which we should definitely see is the definition part. So in the definition part, there are 4 or 5 words which are very important and very crucial. The first one is the Benamidar. The second one, the beneficial owner. Third one is the Benami property. So assume, like how I gave an example of A and B involving in a Benami transaction. The person on whose name the property is bought is the Benamidar. And the person who actually gives money to buy the property is the beneficial owner of the property. So he gets the benefit out of it. So he is the beneficial owner. And Benami property is actually the property. So the word person, which will include not just a person, it will include a person, a Hindu undivided family, a company, a firm, an association of person, a body of individuals, and every artificial jurisdictional person. So the point is that everybody, not only an individual, but everybody is brought into the fold of the definition person. So even companies which are involved in Benami transactions are supposed to be brought under the purview of the Benami Act. So just for your understanding, I'll just read as to how the verbatim goes. A Benamidar is a person or a fictitious person, as the case may be, in whose name the Benami property is transferred or held, and includes a person who lends his name. A beneficial owner, a person whether his identity is not known or not known, for whose benefit the Benami transaction happens. Benami property, any property which is subject matter of a Benami transaction, and also includes the proceeds from such property. So if at all there was a Benami transaction and the property was sold, and that is a sale consideration. Now if there is a question whether the sale consideration could be considered Benami property, yes, it is a Benami property, and subsequently persons, which I told you earlier. So next important definition is a Benami transaction. The Act per se defines as to what a Benami transaction is in a very wide manner. It has 4 A, B, C, D, 4 important clauses. So I've segregated them for your better understanding. So a Benami transaction is a transaction or an arrangement where a property is transferred to or is held by a person, and the consideration of such property has been provided or paid by another person. A very simple layman interpretation of what a Benami would be. Then, and the property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. Now there is an exception to this, which will come in the next slide. So the second one is a transaction or an arrangement in respect of a property carried out or made in a fictitious name. So it need not necessarily be an individual, it could be anybody or anything. Even if it is the name of a trust, then it could be brought into the fold of the Benami law. The third one is a transaction or an arrangement in respect of a property where the owner of a property is not aware or denies knowledge of such ownership. This is a very important provision. Whereas there will be several people, if you will be like you could have got acquainted to people from villages, they will not even know that they own the property. It would have been got by their bosses somewhere, like without even their knowledge. So even that property were brought into the fold of the Benami transactions. And finally, a transaction or an arrangement in respect of a property where the person providing the consideration is not traceable or fictitious. In fact, the main question will be there should be 3 ingredients for any person to define a Benami transaction. Number 1, like I said, a Benamidar, the person who owns the property, in whose name the property stands. Number 2 is the beneficial owner who has actually given money to buy the property or who is getting benefited out of the property. And third one is the Benami property. Now this clause makes it clear that even if there is a surmises or there is a presumption drawn by the authority that thinking that A does not have, assume A has been filing his returns and he has been filing a menial amount of total income somewhere between 5 to 10 lakhs on an annual basis. Subsequently, in 3 or 4 years to come, he buys a property for 1 crore. So now the point is that this transaction from his returns will show that he is not capacitated, like he is not eligible to buy a property of this. Maybe he will not have source to buy such a huge property of this money. So the point is, now the question as to whether he could be bought, because maybe he had received money from somewhere else, maybe, but it is for him to prove that the money has come through a legal source, failing which he will be booked under clause D, which says that a transaction or arrangement in respect of a property where the person providing consideration is not traceable or fictitious. So in this case, maybe he had got it from somebody else, but he will be booked saying that he is the beneficial owner, whereas the Benamidar is not known. So that will be the transaction here. That is how the Benami Act will proceed with respect to the following clause. And the next one is the exemption to the previous, where the property is held in the immediate or future benefit, direct or indirect, of the person who has provided the consideration, except when the property is held by, it includes a karta or a member of a Hindu undivided family, held for his benefit or the benefit of other family members in the family. Then person standing in the fiduciary capacity, like a trustee, under the benefit of another person towards whom he stands in such capacity, and it includes a trustee, executor, a partner, a director of a company, a depository, and a participant as an agent of depository under the Depositories Act 1996, in the name of a spouse or in the name of any such child of such individual. So fourth one is as a joint owner in the name of his brother or sister or real ascendant or a descendant. Finally, possession of a property taken or restrained in part performance to a contract under section 53A of Transfer of Property Act. So these 5 transactions are exempted from being booked as a Benami transaction. So the next part is that, having come to end of the important definitions, now I would like to take you through the 3 charging sections of the Act. The first one is section 3, and then section 5 and section 8. So section 3 deals with a prohibition of a Benami transaction. So it reads as such: no person shall enter into any Benami transaction. This is a specific clause. And subsequently, whoever enters into any Benami transaction shall be punishable with imprisonment for a term which may extend to 3 years, or fine, or with both. And third one, whoever enters into any Benami transaction on or after the date of commencement of the Benami transaction shall, Act 2016, shall, notwithstanding any contained in subsection 2, be punishable in accordance with the provisions of Chapter 7, that is the offences and the prosecution. So, if somebody engages in the Benami transaction, number 1, he will be entitled for imprisonment of 3 years, and subsequently a fine, or at times the both. So, apart from that, section 5.
Previous section, 3 subsection 3.
Yes, sir.
Is anything provided there? Because 3.2 is with respect to S2I law.
Correct, sir.
3.3 is after the Amendment Act is come.
Okay, sir.
This Amendment Act, Benami Transaction Prohibition Amendment Act is effective from 1st November 2016.
16, yes.
Any offence on or before 1/11/16, for that 3.2 is applicable.
Correct.
Afterwards 3.3 is applicable.
Correct, sir. Yes.
In this area, some dispute is there.
True, sir. I'll deal with all the legal parts as to how.
3.3 has not come here. That is why I asked.
Okay. Maybe
That is the main point.
Okay, right.
As per the
Right.
new law.
Okay. Maybe I'll deal with it in the further course of it.
Okay.
So the next portion is section 5 of the Act, which is the heading of the Act is that property held Benami liable to confiscation. So it says any property which is subject matter of Benami transaction shall be liable to be confiscated by the settled government. So if at all, this is not available in the old Act. So if at all any property is found to be Benami at the end of the proceedings under the Benami Act, then it will be confiscated by the central government. And finally, section 8, which defines the composition of the authority or the adjudicating body as such. An adjudicating authority shall consist of a chairperson and at least 2 other members as well. So I'll deal with it one by one. So once the 2016 Act came into play, the main important ingredient or main important work that the legislature has had to put in place some executive body to work on these transactions alone. So the income tax department was identified to work on this because they have the record of most of the transactions as such, and a new unit called the Benami Prohibition Unit was established through a communication of CPDD dated 5/4/2017. So since then they have been working on the Benami transactions as such. Each Benami Prohibition Unit had an additional or joint commissioner Benami Prohibition, deputy or assistant commissioner Benami Prohibition, then income tax offices and other officials relating to the Benami Prohibition body alone. So the main objective of the Benami Prohibition unit is to perform all duties and functions of investigation authority and adjudicating authority and administer under the PBD Act, and also criminal prosecution related to monitoring and coordination functions under Black Money Act and Income Tax Act. So the entire framework works. The framework for the Benami Prohibition starts from the Income Tax Act. So whenever a search happens or whenever an assessment is done, basing on this assessment is where the inputs for Benami starts. So individually, apart from defining authorities, section 18 put in place 5 or 4 important authorities as such. Number 1 is the initiating officer. So an initiating officer is an assistant commissioner or deputy commissioner as defined under so and so of the Income Tax Act. So technically, who is an initiating officer? So initiating officer is the person who, on receipt of information from any other authority, any other governmental body, will initiate actions under the provisions of the Benami law. So subsequently, the approving authority. So when he initiates a proceeding, which I am going to deal further. So when he initiates proceeding and he comes to a knowledge that yes, this is a Benami transaction, then he'll pass an order under section 24, and then he'll be forwarded to the adjudicating authority who sits in Delhi. So before sending it to the adjudicating authority, he should get the approval of the approving authority, who is an additional commissioner or a joint commissioner, a superior officer to the initiating officer, to confirm if the transactions are in place. And subsequently, administrator is a person who, as per the act, is an income tax officer, but technically his work is to govern the property that has been confiscated. Of course, not too many confiscation has happened so far because the act is very new. So his role as such is very small and it is yet to be defined completely. So starting with the highest authority, the adjudicating authority. The adjudicating authority consists of a chairperson and 2 other members. It is appointed by the central government. The adjudicating authority will have members of the Indian Revenue Service who has held the post of Commissioner of Income Tax or equivalent, or Indian Legal Service who has held the post of a Joint Secretary or equivalent. So whenever a chairperson and the other authorities are appointed, and adjudicating authorities are appointed, the adjudication should happen in a bench. A bench should have at least 2 members and it sits in Delhi. So this bench will, of course, take care of the entire proceedings from the collation of materials done by the initiating officer to coming to a consensus if the transaction is Benami transaction or not. So about the adjudicating authority, it has been bestowed with the responsibility of making its own laws. So whatever it is required, it can make its own laws, and it is definitely not bound by the Code of Civil Procedure. It shall have its own power to regulate its own procedure subject to 2 conditions. The first condition being, it should follow the principles of natural justice, that is, it should give an opportunity of hearing to everybody. And second thing, it should be in consonance with the provisions of other acts as well as this act. So the important point is that though adjudicating authority is like a civil court, it can regulate its own policies. As such, like assuming just giving an example, there is no necessity for giving adequate time. If at all the adjudicating authority thinks that 3 or 4 weeks is sufficient. Now, like CPC, you cannot make an application to extend a time or something which if you need a time, or for a counter statement. It will just bring in its own laws and principles to govern the provisions of the act. And powers of other authorities, similarly, they have the power of a civil court. So they have the power to of discovery and inspection, enforcing the attendance of any person, like how the Income Tax Act was, including any official of a banking company or a public financial institution or any other immediate intermediary or reporting entity, and examining him on oath, compelling the production of books of accounts and other documents, issuing commissions, receiving evidence on affidavits, and subsequently it also has the power to call for information, impound documents, and conduct inquiry of any person who is involved or who is supposed to be examined for sake of the Benami transaction. So apart from this, the most important part, or where we should actually get into, is how the procedure works. So section 24 defines as to how the initiating officer or all the authorities should function. Initially, when somebody, when some Benami transaction has actually happened, and a report has been sent by, assume a deputy director or an AD or some assistant commissioner or deputy commissioner, an assessing officer, to the Benami Prohibition unit. So he will collect all the materials, and under section 21, he will give in writing, he will send 2 things. Number 1, a notice under section 24(1), whereby he will say that he has a reason to believe that any person is Benamidar of the property. One important thing and one distinguishing factor about this law is that with the 24(1) notice, he will also simultaneously send a notice but under section 24(3), whereby he will say that he is attached to your property. So this is most crucial and important point. So first point is that the initiating officer will send a notice under section 24(1) of the Act saying that he has initiated the Benami proceedings because he had a reason to believe that there is a transaction which is Benami in nature. The reason should be recorded in writing, and a notice has to be sent to all the parties, not just to the Benamidar but also to the beneficial owner. So along with this 24(1) notice, he will also send a provisional attachment order under section 24(3) of the Act. So one important or one crucial point about the Benami law is that it's time bound. So the time given to the initiating officer to conduct this preliminary inquiry and pass the papers along to the next level authority, that is the adjudicating authority, which sits at Delhi, is only 90 days. So during the preliminary inquiry, like I said earlier, he will summon you, he will summon all the parties whom he thinks is necessary for him to draw inference and ascertain whether the transaction is Benami or not. And finally, after having come to a conclusion whether it's Benami or not, he has two options. Number one, pass an order for continuation of such provisional attachment made, or remove the provisional attachment. So when he passes an order of continuing the provisional attachment, it means that he has prima facie belief that the transaction is Benami in nature. So what he does is he will collect all the documents that he has to prove that it is Benami in nature, and he will forward it to the adjudicating authority, which is in Delhi. So for this forwarding, he needs the approval of the approving authority, who is a joint commissioner or an additional commissioner who is specifically appointed for this purpose. So subsequently, section 24 gives the power, like I read it, gives the power for the initiating officer to initiate proceedings under section 24 of the Benami Act. Under section 24(3), he will parallelly provisionally attach the property, and then you will be given an option to showcase whether the transaction is a Benami or not. And finally, having come to a conclusion if it is Benami or not, he might either continue the attachment and forward the papers to the adjudicating authority in Delhi, or he might remove the provisional attachment. Technically, the second part of removing will never happen, because like I said, the authority are the officers from the income tax department, and you know how it goes. So technically, they will have to forward the papers to the next level. Subsequently, it comes section 26 of the Act, which deals with the next level, that is the adjudication before the adjudicating authority. Adjudicating authority is a superior authority which has again people from the department working for them. So not to reiterate, but the entire it's going to be a repeat of whatever happened in the preliminary proceedings. So what happens under 26 is that a notice has to be issued to the Benamidar, beneficial owner, and any other person who has made a claim in respect of the property. So everybody should be here. Subsequently, the adjudicating authority may suo moto or on an application strike out or add the name of any party. So assuming a Benami color has been given to a transaction and he has included some 6 people. Now the adjudicating authority believes that last 3 people are not necessary for this transaction. Then the adjudicating authority has the power to remove it. Subsequently, the adjudicating authority on the prima facie documents given by the initiating officer and the documents or representations will come to a conclusion whether the transaction is Benami or not. If the transaction is found to be not Benami in nature, then the attachment will be revoked. However, if the transaction is found to be Benami in nature, then it will follow the next stage. The most important and the most crucial part of the law is confiscation, whereby under section 27, the entire property or whatever has been attached will become the property of the government. So one important point which I have to definitely say is that like I said, it's a time bound process, and the time that is stipulated for the adjudicating authority to complete the proceedings is only 1 year. So within 1 year's time, he has to brush upon all the documents and pass a final order. This is followed by an appeal before the appellate tribunal. So section 27 clearly says that if at all the provisions of the Act have been found to be violated, then the property will be confiscated. Since I again said that these are the people from the department and they will be pro-department, so we have no other choice but to approach the appellate forum in most of the cases. So section 30 to 46 defines the power of the appellate tribunal. Appellate tribunal consists of a chairperson and 2 other members like the adjudicating authority, but one difference is that it has a retired a High Court judge who will be the chairperson and will be sitting. It again has two other members. Number one, judicial member who is a part of the Indian Legal Service and has held a post of at least an additional secretary or more. And administrative member is an IRS. So what happens in the appellate tribunal is that most of the cases practically from 10 to 80%, 80% of the cases, or rather 60% of the cases, the confirmation, the attachment and the Benami provisions are confirmed. But in 40% of cases, they again send back the cases, or they probably allow the appeal of the appellant. So the next one is the prohibition powers. Appeal to be made within 45 days. So once the order of the final order has been passed by the adjudicating authority, subsequently we'll have to, or the department, if the adjudicating authority has removed the attachment, both the parties can approach, and the appeal has to be filed within 45 days. It has the power to condone delay. That is, if we approach the forum after the limited time that is given, still the appellate authority has the power to adjudicate it. And again, like any other inferior authorities to these in the Benami law, it can formulate its own procedure, and it is not bound to follow the provisions of Civil Procedure Code. And any order is tried, or it's any proceeding that is tried before this forum, is the order passed is equivalent to that of a civil court. So again, the time period to decide the appeal is 1 year. So seeing from the beginning, the initiating officer will have a time period of only 3 months or 90 days. Subsequently, the adjudicating authority will have a period of only 1 year to see in or look into all the papers and pass an order. And subsequently is the appellate tribunal, which again is given only 1 year of time to complete the entire Benami proceedings. So technically, or what will suffice at this point is an appeal before the High Court. So section 49 says that if at all the order is not convincing, both the revenue as well as the appellant can approach or can knock the doors of the High Court under section 49 of the Act. The time for filing the appeal is 60 days and from the date of communication of the order. And again, High Court as usual has the power to condone the delay. Two important points is that, number one, it says there should be a question of law. Like in any other cases, there should be a substantial question of law arising from the order. However, it does not restrict the High Court from deciding all the other issues at large. The Benami transaction, apart from giving out the procedure, also parallelly let out the names of special courts to try the criminal offences as such. So section 50 to 52 of the Act specifically says or empowers courts to try the prosecution part of it. The central government, in consultation with the Chief Justice of any High Court, has to designate one or more courts of sessions as special courts to try all the events relating to the Act. The court shall take cognizance of a complaint, shall not take cognizance of a complaint unless it is in writing and it is by a competent authority. So main point which legally we should see is that if the complaint is made by a competent authority, which is a Benami officer in this case, assuming it is done by any other authority who does not have a power to give such complaint, then maybe we can knock the doors of the court to get it striked off. Again, this is also time bound, so this prosecution part can happen parallelly when your Benami proceedings are going on. So this prosecution part, the trial should commence within a period of 6 months, and the provisions of CRPC is applicable. So again, over this, any order passed in the special court by the special court, you can approach the High Court for by way of an appeal or a revision. Now, the most important part, apart from is confiscating the property or the penalty and prosecution as envisaged in the Income Tax Act. So sections 53 and 54 of the Act deals with the penalty part as well as the prosecution part. 53 reads as for being guilty of offence of Benami transaction, any person who has conducted himself in a Benami transaction will be put to a rigorous imprisonment between 1 year to 7 years, and also should pay a fine of up to 25% of the fair market value of the property. Subsequently, section 54 says that for furnishing false information or documents, rigorous imprisonment of 6 months to 5 years and a fine up to 10% of the market value of the property. And a new section has been brought by the Finance Act 2 of 2019 is 54A. It says that failure to comply with notices or furnish information. So if at all you receive a notice from the department saying that you have been booked under the Benami Act, or any of your clients are booked under the Benami Act, and if at all, and if we fail to give the information or appear before a brother, then that in itself is it is a penal offence, where such person shall be liable to pay a penalty of rupees 25,000 for each such failure. And this, again, like how an income tax proceeding goes, should happen only after giving adequate opportunity to the person, and penalty shall not be imposed if the person on whom the penalty is supposed to be leviable shows a just and sufficient cause. The third one is the prosecution. Like I told, special courts are specifically empowered to do that. So as per section 53(2) of the Act, any person who would be found guilty of an offence under Benami shall be liable for prosecution in circumstances where the Benami transaction is done in order to defeat the provisions of any law, or to avoid payment of statutory dues, or to avoid payment of creditors. And subsequently is followed by sanction under section 55, which says that no prosecution without the permission of the competent authority. This is actually inserted by the recent act. Earlier it was the board. So apparently, to initiate any prosecution, the power has to be approved from CPDT, has to be obtained from CPDT. The recent act has actually taken over the word CPDT and has replaced it with competent authority. And in this case, competent authority is the commissioner, the director, PCAD, or principal director of investigation. So the point is that now the scope of prosecuting any person who is involved in the Benami law is very high, because from getting a permission from CPDT, which is much higher, and bringing it to the level of lower authorities, everybody can see that the scope of how much you can prosecute a person under the Benami law. And again, who may be prosecuted? It has three important people. Like we know, the Benamidar, the beneficial owner, or any person who abets or induces any person to enter into such Benami transaction. So this word, any person, again has a wide connotation. It could include anybody. Like how recently I was attending a conference where one of the panelists was saying even chartered accountants could be brought in the fold of this. So this is how it works. So anybody who is ready to pinpoint the hands on somebody else's name, they could also be brought in the fold of this prosecution part. And most importantly, the offence is by the companies. So every person, now what we know is that with our understanding of how Benami works, what we know is that Benami transaction is on an individual basis. But this Benami law, however, does not restrict it to an individual, but it brings to the fold of a company as well. So it says, section 62 says that every person who was in charge of or responsible to the company at the time when the contravention under the provisions of this act has taken place has to be can be prosecuted and can be brought into the fold of the Benami Act. The contravention has taken place with the consent or connivance of, or is attributed to any neglect on the part of any director, manager, secretary, or other officer of the company. The director, manager, secretary, or other officer shall be liable to be proceeded against and punished accordingly. So the point is that it does not say that only a promoter or only a key person who has been involved in the business has to be penalized or prosecuted. It brings in all level of offices, including the lowest level, like a manager or a secretary or any other officer. So this any other officer or other officer has a wide connotation. So if somebody could be identified to be a part of this transaction, even if he is the lowest level of a peon, he could be brought into the fold of the Benami law. And the final part is that the immunity to such persons is available only if he can prove that only if he can prove that it has happened without his knowledge. So for the purpose of this section, the term company is not restricted only to a company, but it also covers firms, association of persons, and body of individuals. So everybody is brought into the fold of the Benami law with this section, apart from any individual. So if at all, now the question is that assume the transaction has happened in somewhere in 1990s or some recent transaction, and the department sends a notice that we believe it's the transaction is Benami. Now a basic question is that can I sell off this property and can I get rid of this Benami proceedings? The answer is no, because section 6 clearly says that procedure on retransfer of Benami of property by Benamidar. The Benamidar shall not retransfer the property held by him to the beneficial owner or any other person. If done so, such transfer shall be deemed to be null and void. The provisions of this section shall not apply to transfer made in accordance with the provisions of Section 90 of the Finance Act 2016. Subsequently, Section 57 again, certain transfers to be held null and void. Transfer made after issuance of notice under Section 54. So assuming, like how I said, you have received a notice and now you want to get out of the Benami proceedings, and you think selling the property will help me get out of it, technically the answer is no. Because Section 57 says transfers made after issuance of notice under Section 24 shall be ignored, nothing withstanding the Transfer of Properties Act 1882. Then further, on confiscation of property under Section 27 by the central government, any transfer of the property shall be deemed to be null and void technically, because under, like, when the proceedings under 27 takes place, that is, the property becomes the property of the government, you definitely cannot transfer the property. And thirdly, no compensation would be payable by the government for confiscation of a Benami property, and no claim shall lie against the central government for attachment or vacation of attachment of the Benami property. So finally, one thing which with limited number of cases I have dealt so far in Benami, I would try to sum up whatever I know with respect to Benami law. So number one, the law is in a very, like, it's in the growing stage, to be precise. So it's an evolving law, and there are no much decisions to say what is right and what is wrong. So the entire law is evolving, and like there are only a few decisions which have come up in this regard. So that being the case, you cannot say the action of any authority is right or wrong. So you will have to go through Benami proceedings, whatever it is. So if you get a notice from the authority, you definitely will have to appear before him. You will definitely have to produce documents before him. Unless there are reasonable grounds, you will have to go through the Benami proceedings, and there is no law, like there is no any precedence to show that you can get yourself culled out of the Benami proceedings. Second important proceedings, like I said, a Benami notice does not come alone. A show cause notice comes with an attachment order, which says that I have provisionally attached your property because I believe, or I have a reason to believe that you have entered into a Benami transaction. So the law fixes the burden of proof on the onus on the person who is called a Benamidar or a beneficial owner. So prima facie, unless you are able to prove that, you cannot get rid of the proceedings. So the burden of proof is completely on the Benamidar and the beneficial owner, and as such you cannot get yourself out of the proceedings unless you prove so. And this proving part does not happen technically in the initial level and also before the adjudicating authority unless you go before the appellate forum, because everything is pro department and it has its own risk. And incidents to give Benami color to the transaction is with the department. Now there are several transactions which I have dealt with, which you can keenly say that it's definitely not a Benami transaction. But however, the Benami officer has on a high-handed basis sent a notice saying that I have a reason to believe that it's a Benami transaction. So the entire power is with the department. Since there are no precedents to say what is right and what is wrong, the officers are sending notices left, right, and center without any ignorance to the fact. Whatever information they get, they are ready to issue notices under the Benami law. And more importantly, it's a time-bound process. So time should be followed. So like I said, Section 24 gives only 30 days time for the initiating officer to complete the proceedings, followed by the adjudicating authority to complete the entire proceedings within a period of 1 year, and finally for the appellate authority to decide on the appeal within a period of 1 year. So unless it reaches the High Court part, it is very difficult. Like, it's time-bound manner. In fact, in one case where we had already obtained an order from the High Court for stay, the adjudicating authority is not ready technically, or rather the appellate forum is not ready to adjourn it on a long basis. They just give a very short date, like 2 weeks time, where they want them to be updated as to what happened in the High Court. So this is a time-bound manner, and now there is a new amendment which I had mentioned after the 2019 Act, in the 2009 Finance Act, which says that Section 26(7), which states that if at all a person approaches the court, it was not there earlier, if at all a person approaches the court, then that period when a person has approached the High Court or whatever court it may be, mostly the High Court, so if at all, yeah, bro, the time period on which the case has gone for will not be considered for the period for the point of considering the limitation. So
It's very important.
yes, correct.
Because people immediately got to
Exactly. In fact,
petition, 3 years pending.
definitely, like how sir says, even we have cases where we have the cases pending for 1 or 2 years, and the adjudicating authority or as the case may be, the appellate forum want us to appraise them on a weekly basis or on a fortnight basis.
Update the court status.
So maybe that is the reason why they have brought in this amendment. So so my understanding of Benami law with the limited number of work I have done so far is that it's totally a draconian law, and it can be given to anybody. Like we may not even expect, but we may get a Benami notice tomorrow saying that there is one transaction which they believe that it is Benami in nature. So the law is draconian and it is evolving. So we can as practicing professionals, both chartered accountants and the advocates, has a proximity of getting too many litigations through this act for now. So that is the good side of it, and the bad side is that everybody gets a notice, invariably. So these are the main overviews which I wanted to give you about the law. Since the law is evolving, I think there will be much more sessions on this, and I believe too many decisions of the High Court and Supreme Court are going to bounce in, which will make us create as to how the framework should work. So with that, I conclude my presentation for now. If anybody has a question, like, I'd be happy to take it. Yes, sir.
Before the issue notice,
So I can't hear you.
before issuing notice 24, okay?
Yes.
If any denominator send the property to a person, okay? The person who is buying the property, he does not know whether it's denied property or not, okay? He pays the money to him, okay? He gets the registration.
Sir, it's not audible. Can you come in front if you wouldn't mind?
Saying someone purchase of Benami property in good faith.
Beat me, sir. Like I said, section 20, section 6.
Before issue of 24 what?
Beat me. It doesn't call out anything. That is what I have been trying to say. So section 6.
His point is before provisional attachment,
Okay.
any genuine buyer bought property from Benami Dara.
Oh, before issuing notice.
Before issuing.
Sir, like I said,
Before provisional attachment.
Sir, like I said, the act is evolving and it's pro department. So what happens is, technically what happens is, see, before getting into the point whether the transaction is right or wrong, technically what happens is you will get a notice under 24(1) with an order of attachment. So like it says, it's any other party who is essential. So what will happen is, he will call you a beneficial owner, saying that he is the Benamidar, X is the Benamidar, and Y is the beneficial owner, and you having received the property, you should also be a part of the proceedings. So he might include you in, and he might like take the proceedings forward. So only at the appellate level you will be able to prove.
No. The point is, let's say Benami transaction taken place on some date 1st November.
Okay.
So 10th November it has been sold to genuine buyer some X.
Okay.
Afterwards notice served, attachment, provisional attachment taking place.
Okay.
So in between this X is a genuine buyer.
Okay.
Now what is the status?
Any of the proceeds of the sale proceeds of the sale can be confiscated. No?
Definitely, that is the point, sir. Like I said, the consideration will be there. Which I was saying earlier as an example, the department can take two stands. Number one, to prosecute under D or C, where they say the consideration is the Benami property here.
Consideration from the seller point.
From the seller point of view.
But he is holding the property. Buyer, genuine buyer is holding the property.
Correct, sir. Correct. I'm not disputing it. The point is that what happens technically is that the authority has the power to issue notice to anybody and everybody whom he believes prima facie is the Benamidar or a beneficial owner. So he might say that you are the beneficial owner and issue a notice. So it will be on us, the onus will be on us to prove if the transaction is right or wrong, if you would understand. So the point I'm trying to make is that you cannot say that I will not receive a notice. You will receive a notice and you should prove that this is the case.
But at the time of issuing the notice, he is not at all the owner of the property.
That is the point.
No, but sir said the transaction has happened before the issue of notice, no?
That is what? When the notice is issued,
Yes.
the person to whom the notice is issued is not the owner of the property.
That's what I'm saying. See, in this case, my understanding is the Benami officer will have two options. Number one, he can say the proceeds to be the Benami property, because Benami property does not mean only the property. It could include money, cash equivalent also. So what he will say is that the consideration is the Benami property. Now assume in this case, like how sir says, the notice is sent to a third person who is bona fide purchased the property. Now the department or the initiating officer will take a view that beneficial notice is a different person and you are the Benamidar. He might take a stand. Like assuming let me put you through a situation, sir. Like A has two Benamis, A, X and Y. So X transfers property to Y. Is it not Benami in nature still?
Yes, paid the money.
True, sir. I am not disputing it. I am just saying that you cannot prevent yourself from receiving a notice from the initiating officer.
Even for sending the notice, there must be some substance. Bona fide faith somebody purchased the property.
Actually,
simply initiating officer cannot send a notice.
But that is how proceedings are going on for now.
No.
For you.
Actually, we have paid the money. Okay, suppose I am the buyer. Okay,
Okay.
I have paid the amount. I have paid stamp duty. While purchasing the product, I have taken EC. I have taken legal opinion. Everything is in the name of seller only. Okay.
I understand everything, sir. But the procedure is under 24(1), you will get a notice calling yourself as a Benamidar or a beneficial owner, along with the 24(3) notice saying that your property is attached. Now you should appear before the initiating officer, say no, I have got it in good faith. So please relieve me out of all these proceedings. He will say no, you are a Benamidar or a beneficial owner. He will forward it to the next level authority, who will again say yes, you are a Benamidar or beneficial owner. That is technically happening. But as per law, he has the power to release off the claim made by him also. Like I said, section 24 empowers him to release the provisional attachment made also, which does not happen.
Means nowadays, if a client want to purchase the property, he want to first check the source of buying the property.
No, he will know the source of buying. He will know the source of buying the property when he receives a notice from the Benami.
No. First, you have to check the source of the buyer.
I have two simple questions.
Okay.
Yes, sir.
If the consideration is paid by bank transaction by A for the property which is to be purchased in name of B, will this act apply?
The consideration is
If B purchased the property for 1 crore, I paid the consideration by bank transaction to the seller, property listed in the name of B. Will that be treated as a Benami transaction?
definitely, sir. Okay. Definitely.
Okay, we will take it next level. And when the maximum penalty is 35% and 25% and 10%, can you explain how the confiscation will come? You said market value, on the market value 25% plus 10%. There are two penalization clauses.
Correct.
So when the market values arrive, let's say 1 crore, and the government is taking the 1 crore property, will they give 65 lakhs to the Benamidar? I just wanted you to highlight the
Can you emphasize the last part of the
maximum
question?
penalty is 25% on one class, another class is 10%,
Correct. Yeah.
and 6 to 7 years imprisonment is there. Okay, we will imprison, we'll go into the cell and we'll enjoy life, that's a different issue. But what I'm trying to ask you is, the government is arriving the market value is 7 crore, and the maximum penalty is 35%. Will the government give 65 lakhs to the Benamidar?
No, he'll take 1 crore plus 35.
No, you said maximum value, market value into 35% only you said. No, the law says that.
No, penalty is it's like how we compute our the demand is made, like how in our income tax transactions.
Sir, you read the act, I'm
Yes.
reading from the act only.
Okay.
One class is says 25%, another class is 10%.
Okay.
When 35% is paid, I should be relieved from the problem. No, that's what my question. Please enlighten this.
No, I think maybe I did not make myself clear on that point. See, penalty is like how the income tax proceedings also goes. Like it's like equivalent to the penalty under 271(1)(c) or any other provision. So both the two different proceedings technically. So that's what it is.
So your point.
Confiscation is equivalent to, like, let me equate it.
In
Confiscation.
addition to confiscation, penalty to be paid additional.
Exactly. So see, it's merely like how an assessment goes. So like how you pay penalty on apart from what the tax is being asked for. So there are three wings to it. Number one is confiscation. Number two, penalty, and number three is prosecution.
But fundamentally, there should be property in this would correct this.
There should be a property, and this property could be anything. It could be a money equivalent also. If somebody says, no, it could be a money equivalent also, because we dealt a case where they said that there was there was around some 30 crores or something
Transaction.
transaction, and he was not able to show the source of the transaction. So he booked, the Benami officer booked him under clause D, where he says he is the Benamidar and fictitious, and the owner is not known. The owner is fictitious.
And already income tax, we have unexplained credit and all, we are.
No, sir, this is how the proceedings go. I totally understand. No, but this is how the proceedings go before the Benami offices.
So then, income tax officer can refer to the BPO.
The prime facie source of all the information is from a search or from the investigation done by the.
Even normal scrutiny also, any transaction is not getting.
Definitely, he has every power to refer it to the Benami officer, because the Act itself says that all the, in fact, the Benami law, the income tax law, the Black Money Act, and all these acts, they work in hand. So
What a minimum cap is less than 1 crore or more than.
nothing, no cap as such. Even if the property is worth 5 lakhs, they can attach. They can say that this is a Benami property, though there is no cap as such. And one important part is there is no compounding option available till date. So you'll have to go to prosecution.
Mr. Prasanth, again when it is another ridiculous question.
No, definitely.
I know consciously I am asking this question. Under Income Tax Act, you are having undisclosed income, you are paying one-time tax and maximum 300 times penalty. Okay, so totally 400% comes and it is almost taking 100% of the asset. Then where is the question of once again is confiscating the asset and there is once again putting 35% penalty? I don't understand. Please enlighten. How many areas you will utilize asset?
If anybody is doing Benami transaction, advise low value properties only.
Sir, I understand your anguish in the act, but the point is like we are helpless.
Where we should speak, we don't know.
Okay.
How to speak, we don't know.
Sir, like I've been telling you right from the beginning, see, the law is evolving. That is the only point. There is no fixed like precedence to say that this is correct, this is wrong, this is how you should go, this is how you should not go. So since it is in a very prenuptial stage to define it, there is no clear-cut ways or mechanisms like given so far. So we just go with the act, these 72 sections as such, and what I see is that your remedy is more before the appellate forum or the High Court rather than before the lower level offices, because the point being they are pro-revenue, and though these people are people of the revenue department, so you cannot expect anything more. It's like how an assessment go.
Yeah, the law cannot multiply excuse a necessity, right?
You speak of double jeopardy, but I don't know how to explain it, but that's how the legislation is.
I understand.
Income tax itself is shaped such that all your penalties, fines, interests are supposed to be reasonable. They never be overboard. They never go overboard. That is the logic behind it. But as Prasanth rightfully pointed out at the start, it's very draconian, where the entire fair market value of the property will be seized, then 10% of that also, then additionally penalty. Apart from this, you'll have income tax proceedings also. And you may have other consequential proceedings that may come up if you are a government employee also. So there are significant repercussions. Yes, sorry.
If the proceedings,
And the assessee will get money.
if the proceeds of the Benami transaction
You have to take
are
loans.
utilized in a business, say the business is genuine business, then what? Then say I'm forming a partnership firm with some other person who is not at all in this transaction, and I as a partner, I am utilizing those proceeds in the business as my capital. Then whether that partnership firm also will be under the ambit of this.
I think
Benami
I spoke about section 62.
Okay.
The department will see, technically you might have a good case, but the department will take curfew under section 62 and they will say that yes, the transaction is Benami in nature.
All the partners also will be liable. The business also. The new business.
Everybody. See, it's in the whims and fancies of the department. Nothing is with us. You might be bona fide, but you might receive a notice tomorrow saying that you have gone through a Benami transaction.
See, if between the partners there is an MOU, in the partnership agreement there's a clause saying that if one of the partners is accused of such transaction, the firm and the other partners will not be liable. Will that hold good?
Not at all.
No. Principles of justice, sir. You cannot.
No, but definitely, because recently there was a case, I don't know if I can discuss it also, but where basing on an MOU which does not have a proper, did not have the executant as well as the other party, the department has proceeded saying that it is a Benami transaction. It was not even signed by the next party. It's mere a letter or probably an understanding or a contract, however you call it, where only one, now you cannot even call it a contract because only one party has signed it. The person who was supposed to be the executant has not even signed it. But still the department has gone on a footing that this is a Benami transaction and you are to be held liable.
So many joint venture agreement unsigned, unregistered. What is the status of it?
Like I said, we are the Vincent Basis of the department. So not that they go on for every transaction. See, the basis is with the Income Tax Act. So it comes with a search probably. Mostly it's on, like when a search happens, you can expect all these notices. So when you are searched or you are searched consequently, like maybe it instigates the authority to send the notice under Benami Act. Mostly. That's how I've seen so far. So we cannot say that you will every person will receive it, but every person can receive it, which is like it's not far away.
They say when it comes to Benami,
Very limited case laws, and few case laws which have there is a decision which says that of the Rajasthan High Court, if I'm not wrong, which says that to describe whether the old transactions should be or could be brought into the fold of the new act. I think I was not able to get the judgment per se, but the judgment says yes, the act will be applicable even for the old transactions.
Old transaction even 10 years back?
If they have given some Benami color to it, the proceedings will stand good.
Any transaction of
Any transaction. See, like I said, sir,
somebody had a question. Yes.
What are the precautions, say, we should take for any charitable transaction? Supposing some property used for public purpose or something, protect ourselves from this.
one thing or most important thing is disclosure. You will have to disclose everything. That is the only thing you can ask for, nothing else. So maybe proper disclosure and due diligence before buying a property or before entering into any transactions to protect you. Okay. Section 92, if you say, sir.
I think wherever the trust is having property and there is no purposes.
The permission of the court is necessary. So like how sir says, like if due diligence is done perfectly, maybe we can escape.
So he is asking whatever the transaction has been happened, so that how to protect he is asking.
No, how to protect the general versus
What he is asking. What are the precautions? The transactions already has been done. You said up to 88. Now
Okay.
The trust holds a property which seems to be a Benami transaction.
then we are out of time probably. It's not the time for us to take precautions because already.
Today something, whatever we have to enter some agreement or go for court approval.
Sorry, sir.
Supposing someone has given their property for public purpose or public use,
Okay.
that should not be construed as a Benami purpose. What can we do? What are the precautions we can take?
Like I said, sir, it's only about disclosure and due diligence. See, we cannot definitely say that it's totally an interpretation of the officer. So you cannot say that this is right, whatever it is right, because your forum is somewhere else. Like you should go to them because they does not give you a show cause notice and then ask you to explain. They attach your property. They say, I think you are a Benami. So that being the case, you should only prove your case. I don't technically think you have an option but to get out of it.
It's all at the discretion of the judge, as he says. So, good lawyer knows the law, great lawyer knows the judge. So, we have to apply those principles here. But to add to what he said, I think one of the points he had raised is it should not be opposed to the principles of natural justice. One of the fundamental principles is you could not have preempted the subsequent enactment of the law. So for them to come back and say this transaction happened in 1992, this act was brought into effect from 2019. If you have the genuine documents in place, I don't think it should be a problem, is my opinion, sir, on this matter. Yes, sir.
When the law is introduced, Parliament, Arun Jaitley was speaking, when it is out of the disclosed source, this will not come under Benami Act. But unfortunately, that is not figuring in the final act. Whether still can we take advantage of what he spoke in the Parliament? It is not a TV interview or something. It is the fine print of that particular year's budget.
Memorandum. Yes.
Maybe we can try, sir. Maybe we can try before the High Court.
No, because I will tell you one thing. Suppose one company is just funding by buying a property in the manager's name or something, because go there and sign the power of attorney, they are engaging him through a proper resolution and all. And it is also shown in the books of the company only. Okay, money has also gone from the company. When the source is explained, where is the question of Benemi? And it has been very well taken by the company, yeah, that we have given, and it has been kept in my books also. Okay, in such cases also they have initiated Benemi, whereas when Arun Jaitley spoke in the parliament, not in the TV interview or something, where he said categorically, when the source is explained, Benemi will not come into play. Whereas that is missing in your final act.
Maybe you're right,
I
sir.
take shelter under that is my question.
We can take a shelter, but
No, it is not a command. It is, I mean, when the bill is introduced, it is not, I mean, somebody spoke, it's the finance minister who introduced the bill, he spoke, and that is also captured in your particular years of finance bill or whatever. Okay, whether we can take shelter under that is my question.
sir, if you're speaking about whatever has happened or whatever comments have been made, it cannot make a good role. But what we can do is, if you think the transactions...
My only question is whether finance minister's speech...
Definitely not, sir. It's not in the act. It's not in the act. But what I am trying to say is, if you think you will have to take...
There are cases, in income tax cases,
Yes, exactly.
we have also considered that, that has been considered by many courts, and as far as the Benemi is concerned, it is not tested, as you rightly said, whether it has been considered in the Income Tax Act.
Okay. If that is the case, then maybe we can raise it as a ground before the High Court and try a case, if at all you can come across something. No, truly speaking. Because no case has been tried so far in that way.
We are not quoting from someone else. The person who has introduced, the moment it has come into play, okay, he said it is from the explained source. Okay, Benemi will not trigger. When finally it is missing in your, for that matter, if it is something against us, for that matter, from Income Tax Act also, the 153A, 153B and all, they said they can go for 10 years, whereas that has been missed in the final print. For that they are saying, I will go with memorandum. Our intention is for 10 years, you cannot restrict to 9 years. Whereas when you go to the fine print in your Finance Act, you can travel only up to 9 years. Just have a look at it. So there the department comes, no, this is our memorandum you see. Whether in this case, whether can you see from speech?
Sir, there are, technically speaking, there are no case laws decided in this perspective. Maybe it's a food for thought for my own self. Maybe where...
To add to what Sir said, since Sir regularly appears in the ITAT and we meet each other there on regular basis, many cases we make reference to what was said in the budget preamble and the memorandum, even though sometimes it may not feature in the actual fine print of the law and the section. Very often the intention of the lawmaker is always considered here. So, but when it comes to Benemi, since the provisions are so sweeping, I don't know if we can necessarily take that shield of that. But generally in income tax proceedings, very often, we take shield under what the finance minister has said in the budget. And in course of the budget, what was the preamble, etc. And to solidify what was the intention of the lawmaker.
Only when there is an ambiguity, you have to refer the...
Yes, yes.
When there is no ambiguity, instead of 10 years, they have made 9 years. There is no ambiguity, it is very clear.
I agree, sir. And again, coming back to Benemi, since it is very sweeping, it might be very hard for us to use that necessarily as a shield. Might say yes at that time, but then subsequently they had a change of heart or whatever. That could be the defense. But we know in income tax we do it often, which is, sir, you are also aware. Very often we go back.
Discussion for amendment, subsequent amendment to the act. Maybe it's a fit case for discussion of parliament.
Maybe we can try our luck on a case. And it's a food for thought also. Maybe we can raise it as a ground before any authority.
All the cases are going under luck only. as Mr. Abhishek said, it's all the discretion of the authority.
Correct.
No law, nothing. Today I decide something, I write it. That's how it is going up.
True.
Coming back to the limitations of the time, do you have any point towards the adverse position which is prevailing for 12 years? Can you take the adverse position of ownership versus the Benemi transaction? Because it goes up to 1988.
I don't think so, sir. Because with the law about adverse possession, it's adverse possession is not a right. It's a claim you make for having been in a property for 12 years, with the with the knowledge of the actual owner as opposed by him. So that is what adverse possession is. So adverse possession, the title can be granted by the court, only by the court. see, assume I am in your house.
I am aware.
You are aware of it. Like, so the point is that I don't think you can relate Benami transaction to an adverse position.
A trust property which is holding for more than 20 years after paying the money. Now the Benamis Transaction Act can go back to 1980 and still say that it's a Benami property. In that case, I paid a consideration and property standing more than 12 years in my hand. Can I say that it is not a Benami? And I can say the ownership that under adverse position also. Because somebody is not the one. I am claiming it.
Can you repeat the question, sir?
No, see, the Benami Transaction Act goes up to 1988. It works backward, right?
Correct.
Suppose I am a trust. Somebody was raising this question. I am a trust. I purchased a property from a person, but he was not owning it in the right manner. That transaction was coming under this Benami transaction. Let us say, but the property was purchased 20 years before. I paid genuine transaction. It is purchased. Property standing in the name of the trust. Now can the department say that it is a Benami transaction? So I will confiscate this asset.
Sir, for all the acts in good faith, we have a case. I don't deny the fact that we have a case. But the point is, we don't have a case before the initiating authority because he is not have the habit of considering your representations. That is my point. See, I am not saying we can make any points. Most of the transactions might be genuine also, which we don't know, which we are testing upon. But the point is, how the law works, how the framework is that the time given is very low. So if at all he is going to go to the 91st day, limitation, we will take the curfew of the Limitation Act, we will take our privilege to invoke the Limitation Act, we will say that the order has been passed on the 91st day and he has no authority to do it, so get it quashed. So the point I am trying to make is that, so on this 90 days, what he will be under pressure to pass some order and forward it to the next level authority. And that authority again is bound by the time frame. So they again will have to do something, pass an order, give to the next authority. And being pro-revenue, their option will be to confirm whatever order the lower level authority has passed on most basis. So I have rarely come across circumstances where like the initiating officer has dropped his proceedings, number one. And number two, to be open, to be honest, what I see is like not every Tom, Dick and Harry gets a notice under Benami Act. Only when a person is searched, or when somebody is found to have some clippings of money, those people are put to shield under the act. So though we can expect anything to happen tomorrow, my point is that it comes only out of proceeding of an income tax act.
Absolutely agree with you, and we are also under the same impression. But these all problems comes only when we have come to the seminar.
There are 4 or 5 subsequent transactions.
Will
it apply to book debts?
Sorry, sir?
Will it apply to book debts?
Book debts.
Yes, it does.
It might, sir, but I am it's a very new thought actually. I have not come across. I have not even thought of this.
Even a property consideration also you can make.
Yes, correct, sir. But I am not sure if we can consider book debt as a part of it, and I don't think the department will foresee that angle also. Sir, I can't hear you.
Mike is coming. Book debts, when we had a discussion with the IT, that is with the Benami officer, they are invoking section 69.
69 is like of the Income Tax Act.
Income Tax Act. They are saying, please give us all the details of section 69 addition, and they are trying to invoke Benami Act under that. They are looking at that particular section.
That would be logically flawed because you have 90 days to complete here, whereas time barring for income tax goes on for a very, very long time from the date of search.
So they will make a referral to BPO.
Yeah, exactly. So 90 days only from the date of notice from of the initiating officer. No?
So you're saying they
So
wait till the time barring.
definitely they can take any transaction of way old transactions and can also dispute it.
Sir, there is one case law. Nikarika Jain Vipapsri and that's Jain versus Union of India, Rajasthan. It says that this one, for the reason of foresight, etc., the court has no hesitation to hold that Benami Amendment Act, amending the principal Benami Act enacted with effect from 1st November 16, that is the date determined by the central government is in wisdom for its enforcement, cannot have retrospective effect.
Sir, I think this was subsequently
and
overruled.
it is enforceable with effect from 1st November 16 would be prospective and not retrospective.
I think this was overruled, sir, or it is before the Supreme Court, if I am not wrong, or there is a contemporary High Court, decision which is totally in contra to this, where they have said that it is applicable from 1988. So see, so it does not attain the finality.
One court in favor, one court.
Exactly. So Supreme Court, I think either they have, I'm not sure though, either Supreme Court is contemplating on the issue or it is pending or an order has been passed against this.
Supreme Court not yet.
Then it's probably pending because there are two decisions, one in favor of the SSE and one in favor of the revenue. This is the favor of the SSE and one in favor of the revenue. So both these decisions are totally in contrast to each other, and with my knowledge goes, this is not settled.
Suppose, son, this is the property from the father as a part of will, okay, and there are 4 sons, and the father is the Benamidar of the property, okay. Subsequently, the sons receive notice, then who will be prosecuted? All the 4 sons.
All the 4 sins, yes. Oh, there is a will in the name of one person, huh?
Yeah.
I don't know how you can think of all this.
No, even the
I think we should ask the Benami officer only, but with my knowledge goes, probably the son will be called the Benami, like the will person who is.
No, but it is not fair. For single property, all the 4 sons.
Sorry, sir.
Prostitution.
And the father has.
No, maybe prosecution might stand a bit in, but with respect to like how 115 proceedings would go in Income Tax Act, the legal has to be brought on record.
Okay, but Benami Act says all the Benami jars will be prosecuted. Okay.
Okay.
So beneficial owner.
No, both beneficial owner as well as Benamidar. In fact, there is a third clause saying anybody who awaits to the transaction.
Okay. Now the property has been inherited to children. Okay. To 4 children. For a single property, whether all the 4 children will be prosecuted.
Definitely. See, that's how the statute goes. And like I said, we can agitate all the issues. We can say that it is the act of, it's something in good faith, or you are not in knowledge of all these transactions. You just inherited the property. Okay. Now, the probability of such transaction or such happening is very low with what I know. Though it is, it cannot happen. That is my point. But if at all it happens, then we'll have to prove our case.
Means now the 4 sons has to play the chit game. Okay. Whoever gets the chit, he has to get in jail.
But where does all these happen?
What is happening if it is 8 years, whether the 4 children can imprison for only 2 years, like the point. That is point.
No, maybe prosecution may not stand, sir.
We add one more flavor also. Otherwise, 4 into 7, 28 years. That is the point.
Every 6 months they will rotate.
After payroll, you can come out. That is also
See,
there.
a prosecution is again like everything you can prove your bona fides. Maybe property confiscation might stand, which I'm not sure of, but the other two might, penalty and prosecution, you might be.
No, his question was, father was the Benamidar, he expired, he has given to his sons property. So how prosecution will be leveled?
That's what I'm saying, sir. With respect to penalty and prosecution, this part maybe we can prove our cause saying that, now first, it's an obsolete question, like I'm not sure whether it will happen, that's the second thing, but the point is that my understanding with what I understand is that penalty and prosecution, you will be given an opportunity to show your case. So you can tell them that this is the actual facts of the case and
Even they issue a prosecution notice, to whom they are going to issue?
They'll issue to you.
Why? They may attach the asset, but how prosecution notice will be issued to the sons?
So that's what I'm saying, sir. For prosecution and penalty, you can always take a shield that you are a bona fide person. Okay. See, they may proceed taking any action against you, but you can. What is the prosecution notice? Is only prosecution notice comes only when you are issued with the 24(1) notice and 24(3) notice. It doesn't come right away to you. So only when they are proceeding there, they will parallelly initiate a penalty proceeding and a prosecution proceeding. So if they can show that there is a case in Benami against you, they can very well show that you are entitled for a penalty and prosecution, which I think is how it goes. So everywhere you can prove your case.
What about this accommodation entries? Whether accommodation entries comes under the Benami?
To what extent, sir? Like, can you explain your question?
Accommodation entry X and Y entered into just an agreement. I will sell you the goods from cash. Some adjustment will happen.
Sir, as such, any cash transaction can also be brought into the purview of Benami Act. Okay, it's the prerogative of the officer. So he has an option, but see, they will not invoke Benami Act each and everywhere. There should be a real owner who is not unidentifiable, or who the beneficial owner is somebody else. Benefit should have been accruing to somebody else. I don't think on these transactions they can invoke Benami as such. So accommodating entries are mere, like you said, these are only accommodating entries. So you cannot bring a Benami flavor to it, which is my understanding.
If there are series of 5 transfers,
Okay.
and the first person is a Benami transaction, and what about the last purchaser?
One series.
No, no, I'm asking question.
1988.
I have only one answer for all the questions you ask me, sir.
Within 1 year, the property has been sold for 5 people.
Even over 5 decades.
4 purchasers.
But see, sir, in that case, he would have received a consideration.
No, fine. The last purchaser, he would have done all the due diligence and he would have purchased it. If the first person is a he is the beneficial owner, then what is the impact on this?
I don't see, that's the point, sir. I don't think the department will go to this extent of issuing notices everywhere. Like I said, from the.
He has to confiscate the property.
Okay.
No, he will not have the proceeds with him. He would have spent all the money. Now he will see only the property.
Sir, my understanding or my assumption in this case is maybe he will issue a notice to you. Okay, you can.
The last purchaser.
The last purchaser, he can say that, see, I am not even involved in it. Okay, he can say that I am the last person to.
The last, this, if I am not involved in it, then even the first purchaser can say.
See, like how I said, these are very specific transactions where you can try your luck before the High Courts. On a pragmatic basis, we can try our luck before the High Court. We can file a writ petition. We can just say that this is the transaction. I am no way into it. So let me be culled out of the Benami proceedings. But nobody has done it so far.
Last transaction is gifted to temple.
Okay.
Gifted to temple. Last transaction.
Dharmakarta of temple is
God will be there.
I don't think anybody will give a gift of such a property to a temple, sir.
Why not?
Any properties
are
given
How many?
many religious institutions. Yes, because they want to save by that. To eradicate.
If sir can come up with cases like that, maybe we can also explore as to what we can do.
Then the 72 section will become 7,200 section.
There are probabilities, sir. So, any more questions, sir?
At the moment, there is in the income tax department in Chennai, there is a DPU unit is there.
Yes, it is there. It is the investigation block.
They are the investigation wing.
Very much. For the last 3 years. So we've been doing a couple of cases against them as well. So I am very sure they are very functional.
Initiating officer here it's a corporate circle.
1 or 2%.
Sorry, sir.
Corporate circle 1 is
Oh, okay.
initiating officer. Corporate circle.
So there'll be a specific Benami officer, sir. If at all you're getting notices from a different officer, there's again a case law where it says you cannot get a Benami notice from some other officer. Yeah. There is a judgment called Cascade Energy. So if you can go through it, it's a very technical case, very good case also. So apparently the point is, it should be issued only by the Benami officer. Even if he ceases to be a Benami officer at that point, then you can challenge that.
That's what we are telling. Corporate circle 1 is designated for this purpose.
As an additional role, huh?
Yeah, they only are doing.
Okay.
Yeah. And that.
But recently we have received a couple of notices.
Additional commissioner is the approving authority.
Okay.
And deputy commissioner is the initiating officer. So corporate designate even.
I am not sure about the additional charges, sir. But one thing, whatever notice we have received. Okay, whatever received notices we have received so far, it addresses as Benami prohibition only. So if at all it is issued by some deputy director.
Designate for this purpose. Designated for this.
Oh, designated for this purpose.
Yes.
Okay.
Designated. Yeah, next building only persons are.
Okay.
You have to stop
So thank you so much for yes, sir. Sorry, sir.
Chennai, no adjudication. Delhi only.
Sir, the entire authority is in Delhi, sir. Apart from initiating officer, the papers will get transferred to Delhi. So the complete procedure happens in Delhi. So we have very less role to perform only for that 90 days when notice has been issued.
Apart from the penalty, fair market value of property, you have to pay flight costs and go to Delhi also.
And also the charges for the advocate or attorney are winning this.
Present sir charges is also.
So that's it. Yeah. So thank you so much for patient listening. I believe I made some value addition to this evening, and I'm very delighted to be before you. I hope to see you again. Thank you so much.
Thank you, Prasanth, for very nuanced analysis in a very detailed way. We had some very good, interesting interactions about potential future cases also. So thank you for the wonderful interaction from the audience as well. Have a nice day. Thank you.